Hello everybody, thank you for joining us on this webinar today. My name is Samantha Peacock and I work for Landmark. If you haven't come across the name, Landmark offer a variety of products and services including Metropix, the floor plan software, SmartVal, the instant valuation tool, and AML checks from Compliance in a Box. Today, I'm going to provide for you an update on AML legislation, looking at your obligations and practical ways in which you can fulfil your responsibilities. A key change to the legislation was enacted on the 26th of June this year. You are now required to verify your buyers and domestic politically exposed persons, and I will cover in some detail the implications of both today. Hopefully, I will be able to give you a good steer on this, but if you do have any questions, I will provide contact details at the end of the presentation if you wanted to get in touch directly. So, the first place I want to start is to look at why agents have to undertake anti-money laundering checks. HMRC, who regulate AML compliance for estate agents, have released guidance to help you deal with existing regulations and the implications of the changes. The statistics from government are quite shocking. It is estimated that £100 billion is laundered through the UK property market every year. The sector is under scrutiny after the National Crime Agency reported just 355 suspicious activity reports, or SARS, were submitted by agents in 2015, despite over 1 million property transactions. Many of you might have seen the From Russia with Cash expose on Channel 4 a while ago, which brought the issue to the wider public's attention. The intended aim of the regulations is to prevent the use of illegally obtained funds or terrorist financing from being legitimised through the sale and purchase of property. Many agents have shared their frustrations with me about the new regulations, specifically the inclusion of purchasers and the fact that the agent has nothing to do with the money. I think the point on here on this slide from the guidance is important to recognise and give some context as to why agents are now required to include purchasers in their checks. HMRC advise estate agency businesses do not commonly handle the funds used to buy a property. However, they are a key facilitator in a property sale and come into contact with both parties to the transaction at an early stage, and so are in an ideal position to identify suspicious activity. While we can all be guilty of being focused on collecting ID, utility bills, verified documents, and so on, customer due diligence is a process by which you use the tools at your disposal to assess prospective clients and come to a decision about whether you are prepared to enter into a business relationship with them. As I go through the slides where I quote directly from HMRC or other guidelines, I have highlighted the word risk deliberately to bring attention to the focus the regulations place on you understanding the risk to your business and demonstrating how you are mitigating that risk in your policies and processes. This is also known as KYC, or Know Your Customer, and it involves understanding more about the individual and the nature of the transaction to come to a risk-based assessment. For the most part, this has traditionally been achieved by collecting paper ID, whether that be driving licenses or passports and utility bills, etc. More recently, the property sector has followed financial services and insurance and made electronic checks to help with client verification. The final point on this slide here is critical. No illegal funds need to have passed through the business in order for you to be culpable. HMRC are looking for documented policies and processes that steer staff toward an appropriate risk-based decision when taking on new clients. The changes to the regulations, known as the Fourth Money Laundering Directive, came into effect on the 26th of June 2017. There are two key changes to your existing responsibilities as a result. The first is the need to undertake customer due diligence on buyers in addition to vendors. Importantly and reassuringly, this is not anything over and above what you have been doing for vendors, rather an extension of the existing checks to your purchasers. Second is the requirement to identify and apply enhanced due diligence on UK politically exposed persons, or PEPS. The final point does come up from time to time. You need to apply CDD to beneficial owners of companies, people with 25% or more interest in the business, and executors of the will in probate cases. In terms of the timings, not much has changed here for vendors. You must ensure your customer due diligence is complete prior to entering into a business relationship, so before you list the property. And HMRC will check the date on which the property is published against the date of your client verification. With regard to the new requirements, the guidance from HMRC outlines that purchasers become a customer when the offer is accepted. Therefore, CDD must be completed before contracts are exchanged. Now, in reality, this needs to be as early as possible and can be done any time after an offer is informally accepted. You do not need to undertake retrospective checks on purchases prior to the changes on the 26th of June. So what do HMRC say we need to do to comply with their requirements when it comes to applying customer due diligence? The list here on this slide is taken directly from the regulations, and I suspect includes some of your own current activity. You must, for example, verify that an individual selling a property is legally entitled to do so, refuse to deal with persons or entities you cannot verify their legitimacy, keep and maintain copies of customer due diligence. So for the vast majority of people you deal with, it is enough to demonstrate you have acted in this way. However, a very important point is almost buried in here, and HMRC are very hot on this. You must apply enhanced due diligence to take account of the greater potential for money laundering in higher risk cases, including when the customer is not physically present when being identified, and in respect of politically exposed persons. Where you are identifying higher risk clients, you need to undertake and evidence that you have applied a greater level of check on them. This is known as enhanced due diligence. Applying enhanced due diligence will be dictated by your own risk assessments, policies, and procedures, but HMRC have provided some guidance about indicative behaviours of those who might consider to be high risk. It should be said that this list is not exhaustive. It talks about unusual business behaviour, complicated company structures, people in high-risk areas such as London. We could add to this list cases where there is an unusual necessary haste or the use of an unknown solicitor for the conveyance. There are other transactional red flags that should put you on alert to a higher risk transaction. HMRC's guidance suggests that transactions where private banking is used could be considered high risk, as could the desire for anonymity. Your purchaser wandering into your office with a suitcase full of cash, that is a bit of a red flag too. These are not hard and fast rules or indeed evidence of illegal activity, but they are red flags that should alert you to the need to apply enhanced due diligence. Staff should be trained on identifying potential high-risk scenarios in order to be able to make a decision on whether to apply enhanced due diligence or not. I would suggest that identifying and verifying politically exposed persons is one of the biggest challenges facing estate agents as a result of these changes. Without any definitive list, this is tricky at best, and unless your enhanced due diligence identifies otherwise, you can enter into a business relationship where a PEP is involved, provided you undertake enhanced due diligence and obtain senior management approval to do so. But we do have this. HMRC's guidance does outline who we can consider to be a politically exposed person. So, for example, a member of parliament or members of a governing body or political parties, Supreme Court judges, ambassadors, and high-ranking officials in the army. It also includes family members, such as a spouse or partner, children and their spouse or partner, brothers, sisters, and parents, and known close associates. It does also go on to define who close associates are. The detail of this is available in the guidance from HMRC. And the good news is that HMRC have acknowledged that UK PEPs will present much less of a risk from a money laundering point of view than foreign PEPs, and in such cases, although enhanced due diligence must be applied, a reduced level can be applied. Where enhanced due diligence is appropriate, you will need to evidence your activity. Essentially, you need to demonstrate that you are doing things over and above your customer due diligence. Again, the list here provided by HMRC is indicative and not exhaustive, but it gives you a good idea of what is expected of you when it comes to evidencing your activity. Typically, HMRC suggests enhanced due diligence may include obtaining additional evidence of the individual or individuals you are dealing with, verification of documentation provided, or further clarity on the nature of the transaction, including funding. Ultimately, you can only do what can be reasonably expected of you. You are not solicitors, so a thorough investigation of bank accounts and understanding financial paper trails is not a speciality skill set for most. As such, you would not be expected to go to that level of detail. Electronic checks modernise your AML procedures and tick a number of boxes within the regulations when it comes to applying customer due diligence. If we refer back to the guidance from HMRC on what you must do in order to carry out customer due diligence, electronic checks will enable you to both complete and document the following: customer due diligence on all customers and beneficial owners before entering into a business relationship or occasional transaction, due diligence on the other party to the property sale, give you a procedure to identify those who cannot produce standard documents, a system for keeping copies of customer due diligence and supporting records, and to keep the information up to date. All of this is under a minute. Using electronic data is more thorough than using paper methodologies, as clients invariably have different levels of information they can provide. Some may or may not have passports or driving licenses. Electronic checks provide an interpreted pass or refer result using the data available and identifies those on sanctions lists and politically exposed persons. In a world that is more paperless by the day, requesting paper copies of ID from clients presents a growing challenge. Instead of requesting paper ID from purchasers and potentially slowing the transaction, how much more positive an experience are you providing your client with electronic checks? Instead of valuers chasing photo ID or paper documentation, what if that time could be used to chase new leads and valuations? What impact could this potentially have on your business? What is the perception this leaves your customers with of your business? In other words, are you choosing Blockbuster over Netflix? Collecting a few key pieces of information about your customer will enable you to run a check on their identity and apply a consistent level of customer due diligence when it comes to both clients you meet and clients that you don't. Here you are seeing a short video of just how simple that really is. If we run down the form, you will see how easy it is. You can evidence your risk assessment by adjusting the level of check to normal or high risk. You need to collect full name and date of birth, and you also need 12 months of addresses as a minimum. When we're applying enhanced due diligence, we can add the passport, driving license, national insurance number too, and I quote again from the guidance: take additional measures to verify the original documents supplied. How often are we guilty of historically taking a passport, driving license, or utility bill without really doing any further due diligence? What does it tell us? A good tip I was given not so long ago is that you have your remote clients take a selfie with their ID. In this way, you verify the person in the selfie is the same as the photo on the ID, and you can run the ID number through the electronic check to verify the legitimacy of the document. The checks themselves provide an interpreted result, either pass or refer. A pass result is determined by the number of primary checks made and the particular level of risk associated with the client. The amount of electronic proof required to verify a person for anti-money laundering purposes differs depending on the perceived risk level, either normal or high. For normal risk checks, the JMLSG state that for normal risk, one match on an individual's full name and current address, and a second match on an individual's full name and either his current address or his date of birth is required. 3 primary checks are required for a high-risk pass. The name, date of birth, and address details are run against positive and negative Experian data, which includes both public information. It also includes the electoral register, county court judgments, bankruptcies, administration orders, and the credit account information sharing. This holds information on over 440 million shared account records like bank, mortgage, credit card, utility accounts, and so on. If an individual fails on a sanctions list, you must cease the relationship immediately. Where we have a pass result and the transaction does not throw up any risks or red flags identified on your risk assessment, we have sufficient evidence that you have applied CDD. You do not need to collect any further documentary evidence for the individual. Here is an example of a refer result where we have identified a failure to on both the number of primary checks, and this individual has been flagged as a potential PEP. In these cases, we need to apply enhanced due diligence as identified by your own AML policies. Typically, this will include collecting further evidence of the individual, so things like passport, driving license, utility bills, birth certificate, and so on. We can use the check to verify that document if we have it before we run the check. Where it is flagged, we also need to establish whether the individual is a politically exposed person. Unlike the sanctions check, there is no definitive list of PEPs, so the check is returning an indication of the risk posed using the data. In most cases, if you ask someone if they are a PEP, they'll probably just give you a funny look. You can ask them what they do for a living or whether they are connected to somebody who is a PEP as per the definitions provided by HMRC and make a file note to that effect. In a number of cases, taking these simple steps will rule out the likelihood of the individual being a politically exposed person, and you can continue with the transaction. Where you do identify, you need to follow your AML procedures and obtain approval to continue with the transaction. All searches and reports are retained indefinitely, fulfilling the legal requirement to evidence documentation for 12 months in the case of politically exposed persons and 5 years for the money laundering regulations. All documents are archived by a unique reference number and property address along with a date and timestamp to provide an audit trail for head office and HMRC. The reports are all available 24/7 for download with no charge for retrieval. But before you start panicking too much, Landmark are about to provide a guiding hand. All our customers are able to contact us to discuss cases and results and review options with us. We don't leave you high and dry. As well as being at the end of the phone or email, we have lots of resources to support you. This is one example here on the slide which accompanies every check and gives you a breakdown of what the individual components of the check means and what typical next steps you can take where you need to apply enhanced due diligence. As ever with these sorts of risks, the vast majority of your clients will be ordinary people who are simply looking to move, relocate, upsize, downsize, and they pose no risk to your business from a money laundering perspective. The key objective with all of this is to evidence and document your activity. Thank you so very much for your attention. I hope you found this useful, and if you do have any queries or indeed are interested in finding out more about Landmark and how we can help, then please don't hesitate to get in touch.